And Mr. Murleader, if you wouldn't mind, maybe over here so we keep social distancing and over in this area that we, and make sure you appear on screen right there if you don't mind. That way, as long as you can see yourself right there, then that microphone will pick you up and then we can see Mr. LaPlante. All right, Mr. LaPlante, raise your right hand. Mr. LaPlante, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you may put your hand down. All right, you are Robert Delaplaine, is that correct?
Yes, sir.
Mr. LaPlante, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Murleader. Are you pleased with his representation of you?
Yes, sir.
Do you feel like you've had sufficient time to discuss your case with him and have all of your legal questions answered?
Yes, sir.
Is there anything about this plea agreement that you feel you do not understand?
No, sir.
And Mr. Murleader, do you believe your client to be competent today?
Yes, Your Honor.
All right, it's my understanding that Mr. LaPlante was on community supervision based on his April 12, 2018 hearing where he pled guilty to the offense of evading arrest or detention with a vehicle, third-degree felony, which the court on that day found that there was sufficient evidence to substantiate his guilt. However, the court deferred a finding of guilt on that day, placed him on 3 years community supervision, and assessed a $1,500 fine. It appears to the court that the state filed a motion to adjudicate and to revoke on November 21st of 2019, and they have alleged 5 separate counts in that motion. Mr. Murleader, have you gone over that motion with your client, Mr. LaPlante?
Yes, Your Honor.
Is it his intention to plead true to each one of the counts alleged?
Every count except for count 1, which is the offense from Wood County, and the state is abandoning that count.
That's correct, Your Honor. We're going to abandon count 1 in the state's motion to adjudicate.
Thank you, Mr. Cox. And Mr. Murleader, does your client waive the formal reading of the state's motion to adjudicate?
Yes, Your Honor.
All right, and it appears that the plea agreement Mr. LaPlante has reached with the state is that after abandoning count 1 with pleas are true to counts 2, 3, 4, and 5, that the state's recommendation is that he be adjudicated, that his community supervision be revoked, that he be punished on a lesser included attempted evading arrest or detention under section 1244A with a sentence of 309 days in the county jail with credit for time served and the balance of his financial obligations. Is that your understanding of the plea agreement, Mr. Murleader?
Yes, Your Honor.
Mr. LaPlante, is that your understanding as well?
Yes, sir.
Okay. All right, then, Mr. LaPlante, then I'm going to ask you as to counts 2, 3, 4, and 5, as contained in the state's motion to adjudicate, are those counts true or not true?
True.
And Mr. LaPlante, are you telling me that those counts are true because in fact they are true and for no other reason?
True.
Has anyone threatened you, forced you, or pressured you to plead true to these counts?
No, sir.
All right, court will accept Mr. LaPlante's pleas are true to the counts 2, 3, 4, and 5 as contained in the state's motion to adjudicate. Mr. Murleader, is there any objection to the offer of the defendant's waiver of rights to plea as true as states Exhibit A?
No objection, Your Honor.
All right, court hereby admits states Exhibit A into evidence and takes judicial notice of Mr. LaPlante's judicial confession. Is there anything further from the state?
No, Your Honor. We rest and close.
Anything further from the defense?
No, Your Honor, we rest.
All right, then based on the evidence before the court will find that Mr. LaPlante has violated the terms and conditions of his community supervision. The court will follow the plea agreement in this case. Court hereby adjudicates the guilt of Robert Delaplaine. Court assesses his punishment. Court finds that state has abandoned count 1 of the state's motion to adjudicate. Court finds that the recommendation is that he be punished on a lesser included attempted evading arrest or detention with a vehicle under section 1244A. Court hereby convicts him of that offense and assesses his punishment at 309 days in the Van Zandt County Jail. Court issues credit for time served in that same amount. The court orders him to pay the balance of his financial obligations. Is Mr. LaPlante going to make payments today to discharge his fines and fees and financial obligations, Mr. Murleader?
No, Your Honor, but we've counseled him on how to set up a payment plan with Ms. Bonnie LaPlante, directly after this plea hearing.
All right, and Mr. LaPlante, do you understand that though you've resolved your case today with a time served plea, you understand that when you walk out, you still owe money to Van Zandt County?
Yes, sir.
And you understand that your failure to discharge your financial obligations will result in this court issuing a warrant for your arrest?
Yes, sir.
You just lay it right, yeah, that'd be fine. And then the yellow one's hers.
All right, and Mr. Green, Ms. Red's bondsman has filed a surrender principal release of surety. So there's a warrant for her, so she will be taken into custody at this time.
Okay.
I don't hear it.
Judge, can we hold her for a minute? And-
No, we're gonna.
No, I understand, but give me a chance before y'all take her
Yeah,
anywhere.
well, we're gonna park her right here,
Okay,
Yeah.
talk to Mr. Cox and maybe the court when the court has a break.
but yeah, we're gonna put her in custody here. Who's only got one case? Mr. Stevens? Come on up. CR 27-7, Blake Austin Egret. Am I pronouncing that right, sir? Okay, good. All right, I believe, Mr. Stevens, my docket reflects that Mr. Egret is set for pretrial today, is that correct?
That is correct, Your Honor.
And are there any contested pretrial motions in this case?
Judge, I'm going to ask for one more pretrial setting. My client and I, actually, to be honest with you, met for the first time a while ago. And I've had some issues with the discovery portal, which is probably on my end, not the state's end. So if we could get one more court date, Judge, it would be greatly appreciated.
Any objection about state?
No, Judge, that's fine.
All right, court will reset this for a hearing on September 15th at 9 a.m. All right, Mr. Stevens, once he gets his copy, he gets the yellow copy.
Yes,
Once he
sir.
gets that copy, he's free to go.
May I be excused?
Yes,
Judge?
thank you. Mr. Egret, I need you to report to the pretrial release department with their request. Mr. Alton, you say you had one?
Yes, sir.
Just one? Who do you have, sir?
Scotty Collins, CR 20,
There you are. Scotty Edward Collins. I show Mr. Collins to be set for pretrial.
Yes, Your Honor.
Any contested pretrial motions?
Not at this time. I haven't had a chance to pick up the discovery from the DA's office. I'd ask for another pre-trial so we can get that and I can go over it with my client.
Was discovery made available and you just didn't pick it up? or-
I haven't had a chance to request it yet, Your Honor. I'm going to remedy that this morning and make sure I get that well prior to the next pre-trial.
Any objection from the state?
No, Your Honor.
All right, court will set Mr. Collins in for an additional pretrial on September 15th, 9 a.m. And if you'll fill out that notice of appearance form.
Will do, Your Honor.
Give him the yellow copy. Once he gets that, then Mr. Collins, I need you to report to the pretrial release department. Do you have that notice to say?
Yes.
Yeah, go ahead and fill that out so you can leave me the white one, give him the yellow one.
Good deal. Thanks, sir.
All right, Mr. Knight is set for docket call today, Mr. Manning.
That's correct, Judge.
And Mr. Knight, telling the court that he's been unable to reach a plea agreement with the state, he's requesting a trial.
That's correct, Judge. We reject the state's offer and request to be set in the first trial setting,
And is that for defense trial or jury trial?
jury trial.
And Mr. Knight understands that once he passes docket call, that the court may not entertain a plea agreement. Even if the plea offer gets better, the court may not entertain it.
And I'll explain that to Mr. Knight.
All right, court will set Mr. Knight for jury selection on October 26th. And Mr. Knight, on that day, you're to appear in person on or before 9 a.m. in the basement of the courthouse. You'll be directed by the court staff at that time, okay? And Mr. Knight, I need you to report to the pretrial release department. CR 19-294, Francisco Eduardo Zanella. Dr. Paul, Mr. Manning.
Yes, Judge, and actually, I had an opportunity to speak to Mr. Zanella and another family member this morning, and I have some new information that may be helpful to the prosecutors. I don't know if they'll be willing to extend one more docket call. Otherwise, we're ready to set it for trial.
Dave.
Judge, if there's new information, we wouldn't be opposed to one more docket call setting to try to see if there's any way we could work this one out.
All right, court will set Mr. Zanella then for docket call on September 15th at 9 a.m.
And Judge, we withdraw our motion to withdraw that's previously on file.
Okay, say that again.
We withdraw the motion to withdraw that was previously set for today as well.
Okay, so your motion to withdraw as counsel,
Yes. And what was that? What was that date?
September 15th.
Yes, Judge.
Ms. Beasley, you ready?
Yes, I need Mr.
Mr. Zanella, I need you to report to pretrial release department before you leave. Ms. Beasley, who are you ready on?
Danielle Borchard.
CR 20-72, State versus Daniel Borchardt. All right, Ms. Beasley, I show that pretrial today.
That is correct, Your Honor. I've received most of the discovery, but not all. After talking with Ms. Heisel yesterday, we realized there's one clip of the DVD that I have not received yet. And so they're in the process of trying to provide that to me. And I'd ask, Your Honor, once this case is reset, if my client, who is from Florida, could appear by Zoom at the next appearance.
Any objection from state?
No objection from the state on either matter. We did discover yesterday afternoon that we've copied 2 of the videos, but not the 3rd video in this case. We're working on rectifying that as soon as possible.
All right, court will set an additional pretrial on September 15th. Court will grant the defense's request for the defendant to appear via Zoom. And I would just ask Ms. Beasley that you indicate on your notice of setting the discovery issue that you have so that there's a record of it.
September 15th, Judge?
September 15th.
Okay. She's already signed the reset sheet, Judge.
Okay, and let me, Ms. Beasley, if you'll just, Ms. Borchardt, you'll just have a seat. If you'll just check with pretrial release for me to make sure they don't need her. Usually they're here before she leaves.
I will, Judge. She's already been talking with them.
Okay, just make sure before.
Yes, sir.
And if they say it's okay, then you can go ahead and totally leave. Ms. Borchardt, just have a seat. You wait.
Okay.
Wait. Just have a seat right there in that front row.
Whoop, that's mine.
CR 27-4, Michael David Carrier. Show Mr. Carrier's also set for pretrial.
Yes, Your Honor. I've received the discovery on that case. However, I apologize to the court. I have not had an opportunity to show all of that discovery to him so he can make a decision about what to do with this case. So I'd ask for an additional pretrial setting.
Any objection on state?
No, Your Honor.
And I would ask, Your Honor, if it could be past September 15th.
All right, court will set this for pretrial on September 29th.
Thank you, Your Honor.
That's at 9 a.m.
Yes, Your Honor. May he be excused?
Yes, once he signs the notice of setting, before we get this copy, it's free to go.
Thank you, Your Honor. I had one other possible judge, but I need to speak. Oh, she's approved. I had Representative Jake Burton.
Since Mr. Kaufman has reviewed at least the written discovery, I called this morning. There are some, I don't know actually if they're DVDs or just CDs, but there's some additional recordings that were copied for me this morning that apparently are ready now. I'd like to set this for another pre-trial because I haven't had a chance to review those. I think that's probably going to include victim statement. Wells Point PD would have taken that.
Any objection from the state?
No, Your Honor.
All right, court is for pre-trial on September 29th. Noel, if you'll just ensure that that's written on your notice of appearance form, the DVDs that you're meeting.
Is it possible to set that earlier than that, the 15th?
Or earlier than the 15th? I said on the 29th to give you more time to get the DVDs and review it.
I mean, September 15th, if there's a document then.
There is a document on the 15th, but that only gives you 2 weeks to get the DVDs.
They're ready today.
Okay, yeah, we can set it earlier.
Okay, that'd be fine.
All right, court will set pre-trial then on September 15th, Mr. Kaufman, not the 29th. We'll give you a notice of appearance form, have you sign that.
Judge, the other case that I have on there is, and I think he's on there now, at least I got a text indicating that Mr. McCrary was on.
Do you need Mr. Kaufman? You do. So Mr. Kaufman, after you get this form from your attorney and you sign it, you'll get the yellow copy, and then you need to report to the pretrial release department.